Good afternoon and welcome to today's broadcast. It is Tuesday, March 22nd, and we are speaking about the 24-month OPT STEM extension. Thank you for joining us. My name is Joseph Shepard, and I'm one of the associate attorneys here at the firm. I will be leading us today through the podcast. Attorney Cliff Rosenthal was unable to join us today, so we will focus on the PowerPoint slides and answer questions towards the end. If you have any questions, feel free to type them into your text box on the screen. And as they come up, I will try to get to them. And if we don't, we can go through them at the end if there's time. If for any reason we do not get to your question, feel free to email me directly afterwards at jsheperd@wolfsdorf.com. Once again, this is Joseph Shepard, and thank you for joining today's broadcast. We're going to go over some of the finer points of the new rule and how it affects the way that DSOs, employers, and students will have to operate as a result. For anyone interested in the OPT STEM extension, which will be going into effect May 10th. We'll be speaking about what constitutes a material change and an amended training plan. The new form for the training plan is available online already, so you can take a look at that. The form is called the 983, and we'll be going through some of the finer points of that and what's required for employers and for students in completing and submitting this to the DSO, as well as what the DSO will be required to do with this new form. We'll also be speaking about the employer's obligations and attestations in connection with the training program, including wage and hour, working conditions, etc., as well as for individuals who are currently on the 17-month STEM extension or have an application for a 17-month STEM extension currently pending, what their obligations are and or what their choices are, whether they continue with the 17-month STEM extension or if they apply for the 7-month balance extension and what that really means. So let's start with the basics. As you know, the new rule is a change from the prior 17-month STEM extension, and now it is for 24 months. So that's a total of, for eligible students, 36 months of OPT. This is per degree. So if you have in your lifetime, 2 STEM degrees from qualifying schools, you would be eligible now for 2 STEM extensions throughout the life of your immigration program in the U.S. So if you have a prior degree in a STEM field from a qualifying school within the past 10 years, you can use that as a basis for a STEM extension. If you get another STEM degree at a different level, if you continue, you would be eligible to do a second lifetime OPT STEM extension should the need arise. The job offer for a STEM extension must be directly related, just like the last type of STEM extension, to the actual major or degree. And which we'll talk about in a minute, but the STEM designated list has changed. Effective May 10, there is a new list, and the new list really is pretty much identical except to the old list, except that there are 4 overall 2-digit series fields, which are all inclusive now for CIP codes 14, 26, 27, and 40. We'll talk about that in a moment. The employer still must be registered with E-Verify, but now there are new wage requirements and working condition requirements and reporting requirements for both students and for employers. DSOs have additional work to do as well, including record-keeping requirements with the new form and the students' progress reports, the 12-month initial one and the final one. And there are different rules regarding how long or how much time employers must, or rather have, before they must report a termination or end of the employment, as well as for employees. But the most significant change is the training plan itself. The Form 983. For DSOs specifically, we have a few new requirements. DSOs at the school where the student's record currently is, at the most recent school of attendance, will be responsible for issuing I-20s for the STEM extension, even if it's based on a prior STEM degree from a different school. The prior STEM degrees, if they qualify, and you know, DSOs will also have to discuss this with the students, but that degree must, like I said, must be issued within the previous 10 years of the DSO's recommendation of this. They must be an SEVP certified school at the time that the DSO authorizes this new I-20 for the STEM extension, and that school must be accredited by an accrediting agency recognized by the Department of Education. So as a different or a change from the proposed rule, the actual accreditation and SEVP certification is at the time the student requests and the DSO authorizes the STEM extension OPT I-20. The student must submit the training plan form and all other documents to the DSO. The DSO must keep these records for at least 3 years and must be able to make them available to CVIS or ICE SEVP within 30 days of the student giving it to them. DSOs also must update and keep current the validation reports that students submit every 6 months. If an employer notifies the DSO of a termination of employment under this new rule system, and they must be able to report that to the DSO within 5 business days, or as soon as they know that the person has left that the training or employment program. The DSO must make that information available on CVIS, and the students must report to the DSO any changes in employment or employers or termination of employment within 10 days. So there are 2 different reporters to the DSO for any of those types of changes. We'll talk about material changes as we go on, which are different. They require reporting to the DSO as soon as possible, quote unquote. So that is just something to consider. DSOs also, similar to prior, if they have any, if they believe that there's a non-compliance issue, they have to address that accordingly and may contact, ICE or HSI for follow-up. There's great information online on ICE SEVP's website for DSOs. I highly recommend going through, including step-by-step instructions for DSOs on what the new requirements are with regard to reviewing the 983 training plan that's submitted to them. DSOs cannot recommend the OPT if the 983 is not complete and not signed. The training plan has to explain how the training is directly related to the student's qualifying STEM degree, identify all the goals for the STEM training opportunity, and what knowledge will be imparted to the student, what the goals are and how those goals will be achieved, how the employer will be monitoring and supervising, and also the performance evaluation process. There isn't specific criteria for what that performance evaluation process is above and beyond the 12-month and final, but nonetheless, those need to be included. And also, the DSO needs to make sure that all the fields are properly completed. And like I said, on the Study in the States website from ICE SEVP, there is a step-by-step PowerPoint presentation, interactive, I should say, not so much a presentation or video, that walks through each and every specific field on the Form 983 and what to look for. Just a small nugget of information, the most important thing to look for is the completion of the signatures in all the fields, and that the training program itself actually contains information about the schedule, dates, compensation, hours, knowledge that will be imparted, how the student will be monitored, supervised, and how the goals will be achieved. For employers, what's the requirement here? Well, in addition to being enrolled in E-Verify, similar to under the 17-month STEM extension, the employer now has to provide the 983 together with the student. The employer will be responsible for ensuring that everything in there occurs and that they actually will be providing this training opportunity. In addition to a few other specific items, which I will get into in just a second, about what the employers must do. But like I mentioned during the DSO, must report any changes in material changes to the DSO within, the material changes must be reported to the DSO within not a specific set amount of time, but as soon as possible. If the student leaves the employment opportunity, then they have 5 business days. So if there are 5 business days where the person doesn't show up, they must report that to the DSO if it's not part of a requested leave. And the date that the employer knows the student has left the training opportunity, so that's knowledge, must report to the DSO. But on the training plan itself, there has to be a specific person who will be the point person for this training opportunity. They will be responsible for signing there's 2 sections where they'll be doing attestations. Section 3 is the actual basic information about the schedule, start date, compensation, who is this person. Section 4, however, is that the first of the 2 major attestations by the employer, that the student on the STEM extension will not replace a full or part-time temporary permanent U.S. worker. The terms and conditions of the STEM practical training opportunity, including duties, hours, and compensation, are commensurate with the terms and conditions applicable to the employer's similarly situated U.S. workers. If the employer does not have similarly situated workers, if they don't have 2 or more, then they have to attest that the terms and conditions are commensurate with the other similarly situated U.S. workers in the area of employment. So this sounds very similar to, not identical, but very similar to the H-1B regulations regarding wages. Now, what does that mean in terms of compliance? Well, the employers will be required to have a compliance file in connection with this. It is not explicitly stated in the regs that the employer needs to have said compliance file and, exactly what's in that compliance file, but I can tell you what would be smart to have in that compliance file, in addition, of course, to the form itself. The person who is going to be signing this should be responsible for maintaining these records and be the point person in the event of a site visit, and the site visits are a part of this new rule, and be able to produce these documents, including how they determined what the conditions are for the similarly situated U.S. workers at the company, or if they don't have 2 or more in the area of employment. The employer person who signs and certifies in Section 4 does not necessarily have to be the person who signs in the final section in Section 6, but it can be, and I see no reason why it couldn't be. However, the person who's signing all of these sections will have to assure that everything in there is true and correct, and should be the point person for maintaining the records, speaking with the government and the DSO if necessary, as well as reporting to the DSO. And this is part of an overall compliance, immigration compliance program for employers that is different and new, and will be something that evolves over time, I believe, as the program progresses. But nonetheless, employers would be wise to set up this new training program for their STEM OPT extension employees, and have one central point person at the company be responsible for maintaining and authorizing these and reporting as necessary to the various DSOs, because there will be several DSOs. As the DSO at the school of the student's most recent enrollment is the DSO who will be authorizing the STEM extension regardless of which school the STEM degree is from. So this will be a very important point person or role to ensure, especially for larger employers who will be employing several of these types of non-immigrant workers. The students' 12-month and final self-evaluations, which will document and go through how the student did achieve the goals or how the training program went. The employer will also have to sign and attest that these are in fact true and correct. And then these are submitted to the DSO within 10 days of the reporting period. And let's see, the material changes, like I said, and report early termination to the DSO within 5 business days or upon knowledge that the person has left. The site visit program. So employers, whenever completing and signing and attesting that they will maintain all these new rules and regulations and requirements, also agree to be visited by DHS, and ICE will be likely the agency that will be conducting these site visits. They'll be doing random site visits and targeted site visits to employers. The random site visits will usually be given a 48-hour advance notice, and in some cases, the ICE officers or employees may actually email or call ahead of time to request specific information or documentation, maybe to have ready or to send to them in advance so that maybe they don't even have to do the in-person visit. But nonetheless, 48 hours advance notice for the random, but there also are targeted site visits, which will be upon receipt of a complaint, or if they have some suspicion of non-compliance. They don't have to give advance notice if there is a targeted or responsive site visit. The employer, they may do an inspection similar to the H-1B type of site visit to make sure that there actually is an infrastructure, some kind of office or resources available to provide an actual employer-employee relationship and environment where work can get done. But in this case, more specifically, that they have sufficient resources and supervisory personnel to effectively train. So this doesn't have to amount to a very specific classroom-oriented training program similar to the H3, where there's no productive employment except that which is incidental and necessary to the training. This is a work-based training, and that they want to actually see that the person is being evaluated periodically in some capacity, specifically the capacity outlined in the training program. Inspect the STEM OPT compliance file rate, the wage assessment of similarly situated U.S. workers, either in the area of employment or as employed by the company. If there are other similarly situated U.S. workers at the company in those types of positions, then it would be wise to keep those records, how that was assessed, who is similarly situated in the compliance file as well. And that if there were any material changes in the training program or other types of changes that are considered material explicitly in this context under the new rules, which I'll get into, that those have been properly documented and submitted to the DSO within a reasonable amount of time. It's as soon as possible. So, that will include submitting a new or amended 983 to the DSO with all appropriate signatures as soon as possible. Now, there's a specific provision in the rules that says if there is a material change that is still compliant with the program, and the Form 983 has been revised, amended appropriately, signed, and on file and given to the DSO, that is still permissible, and the employment may continue. The DSO, upon receipt of a material change, amended 983, will ensure that it still meets all the requirements and keep it on file with the other 983 or multiple other 983s for that student, and be able to make them available to SEVIS within 30 days or upon request. But all of these documents and records should be kept by the employer, the employee, and the DSO to ensure that if they are requested ever by USCIS or by ICE, either ICE SEVP through the SEVIS system in the future once they update that, or by ICE through a site visit, that everyone is compliant and that there would be no issues. For students, what does this mean? Well, like I said earlier, they must have a bachelor's or higher in a eligible STEM field from an SEV certified school and an accredited school. The school must be SEVP certified and accredited at the time that the DSO makes the recommendation, and the accreditation of the school must be in place at the time that the student submits to USCIS, the 765. The STEM degree must have been received within the past 10 years of the DSO's recommendation, and the student must be in currently valid OPT. So that is important. And this will also transition somewhat into when we talk about the individuals who are on currently the 17-month STEM extension. Students will be responsible for completing and certifying the Form 983 together with their employers. They must also have an actual employer. The self-employment is not permitted under the STEM OPT 24-month extension. Must report to the DSO every 6 months to complete and verify that the SEVIS info remains and is correct. The self-evaluations. So the student must complete the self-evaluation to show conformance with the training plan and talk about what they have already completed and done, and have their employer sign and confirm that this is true, accurate, and correct. Their employer must be enrolled in E-Verify. And while I didn't talk about this in detail under the employer section, I'll talk about it now. So enrollment in E-Verify would be demonstrated to the DSO by showing, the employer's documentation that is issued to them by the E-Verify system, or if they have a, for example, PEO agreement, a third-party co-employer that would be completing this type of function for them, that they still have nonetheless a, E-Verify client ID number, which would be ascribed to them through that process. The annual self-evaluations, I think it's fairly self-explanatory in terms of what needs to be included into these self-evaluations. The training plan, what needs to be involved in the training plan, and then what did we do through this. So the training plan itself usually involves the goals and objectives and the evaluation of the student and how that progresses. If the deviation from the training plan occurs and the student did not previously report that, that should be done as soon as possible so that there's no surprises in the self-evaluation progress. The student has 10 days to submit the signed self-evaluation under the first 12 months to the DSO after that first 12-month period, and the final one afterwards. The employment with the E-Verify employer must be 20 hours minimum. So if it's full-time or part-time, that must be designated up front. If that changes, for example, if the person will become full-time or the person will be dropping to part-time in a significant number of hours, or if the person's compensation changes significantly, these are all quote-unquote material and must be reported to the DSO as soon as possible. All right. Now, the step-by-step guide that's on ICE SEVP's website, which I do recommend that everyone take a look at, not just DSOs, because DSOs will find it useful to find out what needs to be reviewed, but students and employers will know what they're getting into. In the final rule, the government, DHS, specified how long they think that, how many hours it would take to complete the form. And they, after several comments, they estimate that the collection of information on the form will take an average of 7.5 hours to complete. That is assuming the best and that people understand and know how to complete this form each time. So it's not a easy breezy process, so to speak. However, if one does get into the website and take a look at that PowerPoint presentation, that training program, it's interactive. It's actually really interesting, step by step on the form and literally box by box what's required. You'll see that it can go smoothly and that it is beneficial to have one point person at the company be responsible for completing all of this. So the training program itself, what is the person's degree? So let's talk about what's going into the training program. The training opportunity, similar to a J1 training program perhaps, in a way, we want to talk about what the student wants to gain from the experience. What is the knowledge that they want to attain? What is the practical training opportunity? What is the objective? And so maybe this is modular, maybe this is more broad in scope. Maybe the employer already has a specific training program set forth that STEM OPT students or even other students engage in. We often will be asked whether or not these types of training programs can be used already. Well, the answer is it depends. If it meets all of the current criteria, then maybe. Is it at least 20 hours a week? Is there adequate supervision? How is the person reviewed? It must all be explicitly set forth. The additional record-keeping requirements and attestations under the training, the form itself, the 983, include that the STEM extension student will not be replacing a full-time or part-time temporary or permanent U.S. worker. The duties of the position, so since this is work-based and it doesn't have to be classroom-based, what are the actual duties? What are they going to be doing? How is that related to the qualifying STEM degree which forms the basis of the STEM extension? Are the terms and conditions of employment similar to the U.S. workers? Since this is a training plan, an employer-employee relationship does need to exist. Not all F-1 students necessarily need to have certain types of taxes withheld, but that is above and beyond the scope of this presentation. And if you have any specific questions in that regard, please feel free to reach out. The person who's signing must make sure that all these things are in place and maintain all the records. And I'm not going to beat the dead horse about that. All of the information that is provided on the form, including the employer's FEIN number, should be recorded, and of course a copy of the training plan should be maintained and reviewed periodically to make sure that nothing has changed. Specific to the FEIN number, in the H-1B context, a change in corporate structure does not necessarily arise to a material change, even if the FEIN number of the company changes. Certain record-keeping requirements may be initiated and maintained in order to not require the complete filing of a new LCA and or H-1B amended petition. However, in the STEM OPT 24-month context, a change in the company's FEIN number is a material change that would require an amended 983 training plan and submission to the DSO. So that is one of the biggest new aspects of reporting changes. So, like I said, I believe it would be prudent to have a point person responsible, whoever is already in charge of the immigration program at the company or employer, to periodically review any changes in the company's overall information, including FAN number, with the existing training plans. The employer, the authorized individual of the employer, that employer, whatever FAN number that is, whatever entity that is, must be the same entity that is actually providing the training work experience. So that's an important point as well. Like I said, that there's no self-employment, so an individual cannot sign as the student and on behalf of the company that will be the employer. There must be some separate entity. There must be some other person who is responsible from the perspective of the employer for maintaining these records. That doesn't mean that people can't work for startups and other situations, but there must be an employer-employee relationship, and there must be a separate person who signs on behalf of the company in order to ensure that these attestations are met. All right, moving on. All right. They go to great lengths in the form and in the rules, into the preamble to the final rule, to discuss that the person who is signing on behalf of the company be familiar with all of these rules and be able to certify that, that the terms and conditions are commensurate with similarly situated U.S. workers, and that they are familiar with the student's goals and performance and have the authority to affirm that the statements in the 983 are true and correct. And the employer, importantly, is affirming under penalty of perjury that the statements and information on the form are true and correct. They agree to report material changes to the DSO as soon as possible. And material changes, like I said earlier, include, but are not limited to, and they list a few in the actual rules. Change in the company's FEIN, resulting in the change in corporate structure. Any non-trivial reduction in hours worked. Any significant decrease in hours per week that a student engages in STEM training, and any decrease in the hours below the minimum 20 hours per week required. So going below 20 hours per week would necessarily be in violation of the program, so 20 hours is the minimum. Can the person have 40 hours a week? Of course, yes, they can, and that should be specified in the initial training program. If they go below, if they go part-time, it would be some significant reduction in hours per week. So if they go down to maybe 39 or 38, that would not necessarily be a material change. However, if they go down to 20 hours a week, that would be a material change requiring a amended 983 with filing with the DSO. An amendment 983 does not necessarily have to be submitted to USCIS after such a material change, but this information will be on record with the DSO and the employer should something occur in the future, perhaps a future benefit request, a future immigration benefit request, to ensure that the person has been properly maintaining their status. One of the other big changes is the notion of unemployment during a STEM OPT extension. Under the 12-month post-completion standard, there's 90 days unemployment. With the 24-month STEM extension, the person will be will be permitted up to 150 days total during the whole period. That is only upon approval of the STEM extension. You are employment authorized to begin the STEM extension, continue working during the pendency of the OPT STEM extension as long as it was filed before the end of your current period of OPT. You cannot file for the STEM extension during your 60-day grace period, just like before. You must be in a valid OPT at that time. Another interesting rule that was included in the regs is the change for post-completion OPT. Students must submit the DSOs the I-20 from the DSO within 30 days that they initiated that in CVIS. For the STEM OPT 24-month, they have 60 days from the date that the DSO enters that into CVIS. Nonetheless, of course, it should be submitted as soon as possible. The Form 765 that the STEM extension is submitted to USCIS, that right now, they have not yet updated the form instructions to be inclusive of this new process, and we expect that to come out within the next month or so. USCIS is hosting a webinar on this topic and about the requirements in April, and so we look forward to learning that. The rules in the regulations, they specify that the student may have to include the training program that was submitted to the DSO that served the basis upon which the DSO issued the I-20 recommending the OPT STEM extension, that they may have to file that with USCIS. And in some cases on USCIS's website, as they're updating it periodically step by step, we have seen that they have listed the training plan in the items that would be filed with this 24-month OPT STEM extension. So look out for that and expect that even if it's not initially required, USCIS may request it in a request for evidence, which is something that is relevant for individuals currently on the 17-month OPT STEM extension and may want to apply for the 7-month balance extension, which I'll get into in a moment. I've already said this, there's no self-employment. You must have an employer be the representative, you must have a separate individual who is the authorized individual of the employer. The employer must have an FEIN number and be a separate entity, and must have an employer-employee relationship and be the same entity that's providing the actual practical training experience. All right. Now, for individuals who are currently on the 17-month STEM OPT extension, if your OPT will have 5 months left on it as of May 10th. So there's a window within which you can file for the balance extension. I think that's the next slide, and I'll just go backwards. So if you have 5 months left remaining on that, and you, starting on May 10th, wish to file, you may. You have 90 days where you may file for the balance extension. So you can't wait until the end of it. Say you just got on your 17-month STEM extension. You can't wait till the end of it. You actually only have a 90-day window within which you would be able to file for this balance extension. That is May 10 to August 8. During that period and that period only, individuals can file for the balance extension. Like I said earlier, as slightly different from the standard 12-month post-completion OPT, instead of 30 days from the date of recommendation in CVIS, 60. But the key here is that you have 5 months remaining at least at the time that you apply. If you have a pending 17-month STEM extension and it remains pending through May 9th, on May 10th, if it's still pending, since the new rules apply, USCIS cannot approve it under the 17-month old rules, legacy rules. What they will do, and this is what they've explicitly stated in the new rules, is they will issue RFEs for any of the pending 17-month STEM extensions and will request evidence of meeting the 24-month STEM extension rules. They explicitly will allow for DSOs, they will request explicitly I-20s issued by DSOs for recommending the 24-month STEM extensions dated May 10th or after. So they will explicitly allow that. And so DSOs will be able to issue those. So, you know, like I said earlier, when you cannot apply for a STEM extension during a grace period, if your OPT expires before May 9th or on May 9th, file the 17-month STEM extension while you're still in the OPT period so that you will at least be able to take advantage of the 24-month. You will still be eligible for a STEM extension. It'll just be the 24-month one whenever you get an RFE from USCIS. So file under the 17-month rules before your current post-completion OPT expires, you know, if it expires before May 9th, and if this is what you're intending to do. Upon filing the 17-month STEM extension, under filing the 24 months, so let's just say then after, starting on May 10th, you know, your OPT STEM extension doesn't expire and you know, anytime soon. You still have to apply during the 90 days if you want the balance. If you don't want the balance, you don't have to file anything, and you can remain on your 17-month STEM extension. But that's only if you already have the approval of that, and USCIS will only approve them up through May 9th. So you can still use the 17-month STEM extension, OPT EAD, as long as it was issued before then. USCIS will only issue them before then for any pending ones. If it remains pending, then they'll issue a request for evidence starting on May 10th for documentation, including the training program, including the new I-20 from the DSO under the 24-month, meaning you don't have to pay the filing fee twice. But if you don't want to do the balance, you don't have to. You may continue working on and using your 17-month STEM OPT extension, EAD. To make a point, if you're currently, though, on the 17-month OPT STEM extension and you do file for the balance, if you do that, you have to understand that of the date you file it with USCIS, you and the employer will at that time already have to be in compliance with the 983. So it's upon filing that you're now subject to all these rules and requirements and reporting, etc. If it's approved, then USCIS will issue you another EAD valid for 7 months during the starting on the day after the end date of your current EAD, but you'll need to be in compliance with the 24-month rules as of the date you filed. Once it's approved, however, the only thing that you were not necessarily accorded with the 24-month upon filing, specifically the 150 days of unemployment, that only actually starts to kick in upon approval of the 7-month balance. So keep that in mind. Everything else, all the rules and requirements and reporting requirements and training objectives, all that must be complied with, but you may not take advantage of the unemployment rules or requirements until it's actually approved. If the the 7-month balance extension is denied, then you can go back to and you may continue with the 17-month as if nothing changed, and the rules and requirements at the time that 17-month EAD was issued apply until the expiration date of it. So if you apply for the STEM balance extension and it's denied, you don't lose your eligibility under your current 17-month STEM extension. For individuals who are just starting their post-completion OPT, or maybe have applied for it or are going to apply for it soon, keep in mind of all the dates that govern OPT, right? You can apply for it up to 90 days before and 60 days after your program end date. You have it for a year. For your STEM, if you want to do the STEM 24-month extension, after that, talk to your DSO ahead of time and pay attention to the rules and look for updates from USCIS about what you're going to need, and make sure that the employer knows of these requirements and that they comply. If you get a job right after school under your regular post-completion OPT for the 12-month, that employer does not have to be enrolled in E-Verify. But if you want to do a STEM extension under the new rules the year after with them, they would have to be enrolled in E-Verify. You don't have to have the same employer that you had during your post-completion 12-month as you do for the 24-month. Can you have multiple employers? The answer would be yes. However, they would both, necessarily need to be submitted with a training plan to the DSO. They would both have to meet all the requirements for it. Changes in employment. If you start with a new employer who otherwise meets all these requirements, let's say you're working for company A, you're 6 months into your 24-month OPT STEM extension, and you get a job offer from another company, and they want you to start right away. Well, your current employer, would have to report any termination of your employment within either 5 business days or upon knowledge that you're leaving to the DSO. You have 10 days to report to the DSO. You must submit the training program with the new employer within 10 days of starting at that new employer. If you want to add a second employer and go part-time with the first one, so you'll change from 40 hours per week with employer A to 20 hours per week with employer A and 20 hours a week with employer B, you would have to report the material change and reduction of hours with the first one to the DSO as soon as possible, and you would have to submit the new training program with employer B to the DSO within 10 days of starting. So these are very important considerations. Being also that it's 6 months in, you're required to report with your DSO to validate all your information in CVIS. You still would have to complete the 12-month, you have 6 months until you have to complete the 12-month self-assessment and have that employer A submit that to the DSO. So I highly recommend that you take advantage of the many resources on USCIS and ICE SEVP Study in the States websites regarding what the new requirements are. One other important note I wanted to mention is that the new STEM designated degree program list, it's going to be effective on May 10th, and it already included very specific CIP codes. And the CIP code of your program, your academic program, whether or not it qualifies as STEM, number one, it would be on the list if it is. The current list and the new list are almost identical, except the new list appears shorter, but is really more inclusive because it will permit any of the any of the fields that are included within engineering, which is CIP code 14, biological and biomedical sciences, which is CIP code 26. And for those who don't know what the CIP code, what I'm talking about, the code for that program is a 6-digit number. It's 2 digits, a period or a dot followed by 4, and each one is a very specific field. The engineering code for 14 would be 14 point and then XXXX, whatever those numbers are. Biological and biomedical sciences starts with 26. Mathematics and statistics starts with 27. Physical sciences starts at 40. These would appear on the CIP code. It appears on your I-20 for the program or major for your study. And if your 6-digit code begins with any of those 4 numbers that I just mentioned, 14, 26, 27, or 40, all fields designated under those major categories are now included within the STEM degree program. So as new ones would be added, as new fields emerge, as new programs may come about, those would be included in the STEM list. As prior, there was just a very longer laundry list of fields that fell into those 4 categories. Those aren't the only 2-digit codes. They also include the new STEM degree program list, as well as the prior one from 2012, do include a lot of other fields that ICE SEVP has determined to involve research, innovation, or development of new technologies using engineering, mathematics, computer science, or natural sciences. And so the list of programs outside of those 4 major areas do include lots of different types of fields. And so it's most important, number one, to see if you're eligible as a student for this, to look at the I-20 and see if that field is included in this. And if it's not I-20 related, let's say that perhaps it nonetheless was an SAVP certified school now, and it is accredited now. It's a U.S. institution of education, and you received that bachelor's, master's, or higher degree within the previous 10 years. But maybe you got that, you attended that school while you were, perhaps you went part-time while you were in another status or something similar. And so maybe there was no I-20 associated with it. You can ask the school or contact the school or look at your transcripts from the school and see if that degree program is in fact included in the STEM degree list now. And if it is, that's great, because if that school is now SEVP certified and accredited by an accrediting agency recognized by the Department of Education, which, by the way, all of the resources to help look up what those accreditation agencies would be and what schools are SEVP certified are available on the ICE SEVP website, Study in the States. And that would be fantastic. Presenting all this information, students, I kind of like to give best practice tips to. The DSO is going to be very busy and will likely appreciate greatly, if not require, your assistance in presenting all of this information up front and at one time to say, instead of asking the DSO, does this qualify, presenting, doing the research up front and looking it up to see if it qualifies before and presenting it to the DSO, like, I believe this qualifies. Do you agree? Look, I found the accreditation information from the website. I see that it's on the list of SEVP certified schools, and here's my transcript and degree showing it was issued 9.5 years ago. I have, let's say I'm on a 17-month STEM extension now, and I want to file for the 7-month balance extension. My current OPT, here's a copy of it. It doesn't expire until 6 months, and it's May 11th. Here's my school, here's my employer's E-Verify information and number. The training program that I've developed, with the employer is here. All the signatures are available. my employer has agreed to it. Here's the contact information. It's already going to be on the form, but here's the contact information for the point person at the employer. That will smooth and streamline the ability of the DSO to assist and be able to provide the actual I-20 for you to submit to USCIS as part of your 7-month balance extension request. For same goes with employers. Providing the information that your employer will need will be helpful, but employers in and of themselves will also have to make sure that they have in place a compliance file and program, and work with you if they don't already have one that is compliant. The training program itself, what is required on there. Make sure that their E-Verify information and documentation is up to date. Make sure that they periodically review their compliance file to ensure that there are no material changes that must be reported to the DSO, especially if there's no changes that would disqualify the company from continuing to employ. So overall, I believe that we have about a month and a half before the new rules go into effect, and about a month and a half before any STEM balance extensions can be filed. USCIS will be hosting a webinar on this topic coming up, and we presume that will include updated information about what would be filed with the 765 with USCIS. We presume that it will include the training plan itself in addition to the other information that was submitted to the DSO. And otherwise, if you have any questions on this topic, please do not hesitate to contact your immigration professional. If you want to email us, if you want to email me directly, you can at jsheppherd@wolfstorf.com. Thank you very much for your time and attention, and have a great rest of your day.